With that said, I'm introducing Alan Schwartzseid from our Orlando office, and he is our instructor today for Community Association Collections. Alan, take it away.
All right, thanks, Jeff, and stay safe up there. And we're glad to be a little further south. No offense, but anyway, welcome everyone. And Jeff, I'm kind of disappointed that you didn't get the singing in this time, but I get it. The dad joke might be played out by now. As Jeff mentioned, I'm the managing partner of K. Bender Rembaum's Orlando office. We do have offices in Pompano Beach, Palm Beach, and Tampa, and Miami by appointment. So we really do service the entire state of Florida. I'm willing to go as far north or south as I need to go. And I know most of our attorneys will service whatever clients need. That's the beauty of Zoom. You're here today learning via Zoom. We do have 21 attorneys. We all focus on community association law. 8 of our attorneys are board certified in that area of law, meaning that the Florida bar has given them a special designation that hopefully we know what they're doing, or that they know what they're doing. We also have one attorney who is board certified in construction law on staff. So really a full service law firm that caters only to community associations. So those are the condos, the HOAs, and the co-ops that hopefully are on this meeting today. We do have several circuit and county mediators so that we can really handle anything that comes up that involves community associations that have been formed. We're happy to present this again for your education. But as Jeff mentioned, if your community ever needs legal representation, including past due assessments, mortgage foreclosure issues, bankruptcies that you're dealing with, we really hope you'll think of us. And without further ado, let's just go ahead and get to it. So, background information. Why the heck is an association able to foreclose when someone doesn't pay a $200 assessment when their property is worth $800,000? Now, if your property
Alan,
is...
hang on. If you were sharing, we are not seeing it.
Oh, good call. That might help. All right. Give me 1 second to figure that out. I apologize. Let's see. Share screen. And I believe that should do it. You let me know.
It says you started. There we go. Perfect.
All right.
Carry on,
So
sir.
I'm not going to go back to the first slide because it's really just my contact information. You're going to get it at the end, but I will say the easiest way to reach me is to shoot me an email personally at as@kbrlegal.com. Jeff, if you don't mind throwing that into the chat so that everyone has it a little bit more easily to copy and paste, I'd appreciate that. And we will move on. So again, if you are looking at, let's say, a $800,000 value, and your assessment's only $200 a month, chances are your association's underfunding. But moving on from that, the bottom line is the association gets to foreclose because your declaration says so and the Florida statutes say so. And your declaration was recorded before anyone in your community took ownership, whether you're in a condo, HOA, or co-op. Chapter 718 governing condos, 719 governing co-ops, and 720 that governs HOAs, all of them say you can foreclose this debt, this unpaid assessment. So that's the best possible remedy that the association could have. If someone doesn't pay, it's not just, well, we're out of luck. And if you're looking at it as, well, we're out of luck until someone sells their property, which a client just brought to my attention that their property manager was doing, you are absolutely doing it wrong, period. There's no question about it. You should not be allowing people to get away with not paying their fair share because that's what we're looking at. Assessments that we're talking about collecting today are really everyone's fair share of the expenses of the community that they bought into. So the annual budget for the association is going to determine the amount of those maintenance assessments. You basically use the procedure that's provided in the bylaws or Florida statutes. You take the amount of the budget, you divide it by the number of units. You might have some kind of different configuration, but that's basically the way you're going to determine the assessments for the year. Annual budget divided by number of units is the assessment for each one of those units. Now, you might also have special assessments. Those are the ones that aren't included in the budget. Sometimes that's not the right way to do it because it should have been included in the budget, but you chose not to. That's not something I recommend, but we'll get into budgeting in a separate class, which is the board certification. I'm actually considering, you let me know, please, if it's something you're interested in, a separate budgeting class that we could teach in the future. So if that's something you're interested in, put it on your survey response, shoot me an email, whatever's easiest. Special assessments in particular require 14 days notice that the assessment's going to be considered, its purpose, and the estimated cost posted conspicuously on the property and mailed or delivered by hand or electronically if each member authorizes electronic delivery of those things to the members. So what we're saying here is if you're thinking about a special assessment, just understand you got to provide all of your members 14 days notice before that's levied. Now, in my opinion, and it's not necessarily an opinion shared by everyone, but that's the same notice you should be providing at a minimum if you're planning on levying an assessment related to work that was done on a particular lot, either because they caused damage to common areas or because that particular lot's condition required you to go onto the property and, let's say, pull weeds and have a vendor do that, or cut the grass, something of that nature. Those, in my opinion, you should be providing a 14-day notice as well, because that's basically a special assessment, even though it's not applicable to the entire community. So once the assessments actually are levied, the invoice goes out. This needs to go, and when I say the invoice, I mean whatever method you're using to tell people what they owe for assessments every year, quarter, month, whatever you do. That needs to go out again by first class US mail, electronic transmission to a registered email address, and they need to basically be notified if you're going to change that delivery method. Not only if you're going to change the delivery method, and I'll get into what that means in a minute, do they need to be notified, but they need to actually agree to it. So every member needs to actually agree to accept service of those invoices in a different method if you're going to change it. What that means from practical purposes is if you were sending out coupon books that said, this is what you have to pay every month, and they send their coupon along with their check every month or every quarter, whatever, each member has to actually sign something that says, I agree that instead of these coupon books, I'm going to go to automated payments on my bank. Okay, that's what the association is going to require now. That has to happen at least 30 days before the change in notice. The notice that you give that says, here's your invoice, is deemed delivered upon mailing, meaning it's not the association's obligation to make sure that that notice is actually received by the owners. Okay, it's the obligation of the association to make sure that it's sent out. And again, like I said, each owner must affirmatively acknowledge that they're actually understanding you're changing your delivery method for these invoices in order for you to be able to use that method for that particular lot or unit. What that might mean is that you still have to send those coupon books to 15 of your 100 owners because only those 15 didn't accept some other method of delivery. Now, another thing that even a lot of attorneys seem to miss and a lot of managers and directors have not understood in my experience, and by the way, that experience is practicing in almost exclusively collection law from 2008 until 2018-ish, which is when I started expanding into other areas. So this is an area where I've literally written the book on the subject. I'm very comfortable with it. And I see some things that some other people miss, and that's part of having worked with K. Bender Rembaum from 2010 to 14, and again for the last year and a half, is that I'm not allowed to use the word expert, but the people that are working on your collection work, if you're working with our firm, in my opinion, not the bar's opinion or anyone else's, but are experts in that field. They know that a delinquency is not, well, they didn't pay on time. It's they didn't pay within the time frame stated in the declaration. Many declarations of covenants of condominium are actually not going to say if it's not paid when due, it's late. That's what people are looking at. Is it late? And under a lot of governing documents, it's not late, even though it's not on time for the first 15, 20, 30 days. You got to look at your particular set of governing documents to determine when you can start charging these late fees, if you can charge them, charging interest, etc. Now, I said if you can charge them. Let's get into what you can charge and how and when. So the delinquency date is what's going to be determined in the declaration. Unless the declaration says otherwise, you automatically have the right to charge 18% interest per year from the date of each installment. This is another problem that I see with a lot of communities where management software or their software will automatically charge interest only at the end of each month. And it'll be on the total balance due. Well, you can't charge interest on interest. You can't charge interest on late fees. And you only charge the interest on a per diem basis from the date that each assessment was due. So just understand it's important to calculate these things properly. We'll get into why a little bit later. If the declaration or bylaws provide for late fees, you can charge the greater of $25 or 5% of each installment. So let's recap. Interest is automatic, whether your declaration says so or not. If it says a lower interest rate, then you charge that lower interest rate. If it doesn't have an interest rate or it says the greatest allowed by law, it's going to be 18%. Late fees, you're only allowed to charge if your governing documents allow for them. That's going to be the greater, not the lesser, of $25 or 5% of each delinquent installment. Now, I mentioned earlier, people are charging interest on the wrong things. I said each delinquent installment for late fees. So I want you to understand that doesn't mean that if you have quarterly assessments, you're still charging $25 each month or 5% of that installment each month. You're charging $25 per quarter if your assessments are quarterly, $25 per year if your assessments are annual, plus the interest. Now, costs and reasonable attorney's fees incurred in collection are also recoverable. The distinction between all other kinds of lawsuits and disputes and this is that you have an automatic right, regardless of whether you file a lawsuit, based on the way that the Florida statutes apply any payments that the association receives. We'll go through that in a minute. So you have an automatic right to recover attorney's fees and costs. This is why I think it's foolish at best to say we're not going to take any effort whatsoever to collect our unpaid assessments because we don't want to have to take somebody's house. Okay, I'll get into that comment a little bit later. Owners claiming that they made full payment even though there's interest, late fees, attorney's fees, and costs that have been incurred are dead wrong. Okay, if you have interest, late fees, attorney's fees, or costs, all of those charges get paid before any payment is applied towards the actual delinquent assessment. Now, let me just outline how your payments are supposed to be applied, even though it's later in the presentation. Okay. First, payments go to interest. So if you've got any interest on the account, that gets paid off first, regardless of any restrictive endorsement or anything else the owner writes on their payment. Okay. So if an owner says this is payment for July's assessment and I'm going to sue you if you apply it to any other installment, okay, good for you, but we're applying it to the interest. Okay. Then late fees. Then the costs and attorney's fees incurred in collection, and then finally to the delinquent assessment. So you're applying all of these payments that come in that order. And you don't apply it to the next category until all of the previous category is paid off as of the date that each payment came in. So I don't want to see the association saying, well, they're paid in full because they paid the amount of the assessment this month. No, you have the right to waive interest and late fees. And in some instances, that's a good idea to give the owner a fresh start. But it's not mandatory by any means that you just do away with the interest and late fees because the owner paid the amount of the assessment. Moving forward, should we try to proceed or try and settle? Well, why not do both? I mean, you got two options. You choose the right one. You're going to try and collect, but you're also going to try and settle. You're going to basically have every action that you take in this collection matter be geared toward putting you in a better negotiation position to get it resolved. The further you are in that process, yes, you'll have more attorney's fees and costs incurred, but you'll also be in a closer position to an actual foreclosure sale, which means that you're pressuring the owner more and more to actually pay what they owe you. And that's what I want all of your boards to keep in mind. This is not money that you're trying to get as damages in some personal injury suit that's some vague number that your attorney threw out there. These are dollars that this person owes your association that all of the other members are covering that are actually paying their assessments until this person pays up. What that means is that everyone that's not paying is causing everyone else's assessments to go up. So it's in the board's fiduciary responsibility, which is the highest responsibility that Florida law imposes, to make sure that your members are taken care of and that the people that are not paying are not allowed to just get away with it. Now, aggressive collection policies, which should be in writing, and say that this stuff happens automatically, meaning that the board doesn't have to make the decision of whether to pursue collection or not. It just happens. The manager takes the actions that are required, sends the account over to counsel when it's required, and the attorney moves forward. The board doesn't even need to get involved unless there's a potential settlement. Okay. That type of automation avoids long standing delinquencies. And it also avoids the delay of the board having to make the decision. And sometimes the board doesn't meet other than every quarter or twice a year. Now, I hope that's not the case in your community, but I have seen communities, especially in more rural areas, where you don't want to have everyone get together, but you want to keep conducting your business, which, by the way, is what you are doing if you are on the board of a community association in Florida. You're running a business. Just because it's a not-for-profit business doesn't mean you're still not responsible for the running of a business. So if you were owed money as a business person, you would go after that money. You wouldn't just leave it there because it's costing you money. Here, the problem is it's not just costing the board money to not collect it. It's costing every member of the community money to not collect it. So go after it. Now, you do need to accept partial payments. You just apply them in the statutory manner, where I said interest, late fees, attorney's fees, cost assessments. So you do need to accept all payments that are made on every account. You just apply them the way that the statute requires it. Not accepting those payments because it's not payment in full would be a mistake, because it can actually preclude recovery of attorney's fees and costs incurred after that payment was delivered. It can also have a judge say you're not allowed to foreclose, and you might not be awarded the damages for that payment, even though you didn't accept it because you rejected it. So make sure you accept all payments, even if that means that you take them and forward them on to the attorney, depending on who's doing the work and whether or not you're working with our firm, where we would ask you to pass a resolution that says K. Bender Rembaum can cash these checks for accounts that are in collection and apply the balance towards what's owed. Now, again, a written collection policy is something that I recommend for every community association in Florida. That's in addition to policies governing covenant enforcement, governing records inspections, and governing member speech and participation at meetings. I recommend that 4-policy program for every community association that comes to work with me in our Orlando office. And keep in mind, when I say work with me, what I mean is work with the other 20 attorneys in our firm as well that are a resource that's available to you as a client of the firm. So these policies should say you're automatically submitting to counsel. You're automatically moving forward. There are acceptable settlement terms if someone wants to resolve a delinquency but can't afford to pay up front, whether we can waive interest and late fees, etc. These are things that if they are in a written procedure, everyone knows what to expect. And you know that the board is either going to work with you or not going to tolerate any delinquencies, and that you're not going to just be given 3-4 years of non-payment without any real action being taken. Anytime I see a year-long delinquency without any collection efforts, I cringe, because you're handing this person free money for a year and forcing every other member of the community to make up for it. And I know I've harped on that a lot. That's kind of the purpose of this class, is so that you explain, or I'm sorry, so that you understand how important it is to make sure you're collecting on your unpaid assessments. Now, settlement, and since Jeff didn't sing, I won't burden you with that either, but it's always tease. Are we trying to resolve the debt, or are we trying to foreclose? My opinion, you should be trying to resolve the debt. You should be getting what you're owed and moving forward with your lives, okay? If an owner doesn't have the funds to pay in full, you can accept payment over time. But what I don't want to see the association doing is putting it in an email or a verbal agreement, because that ends up in a he said, she said as to who agreed to what. Even if it's in writing, what I usually will see is that the owner's not waiving any rights in exchange for this 6 months, 3 months, 12, 24 months to pay this debt off. So you're back in the position you started in after waiting 6 months to try and collect, with a little bit of extra money, but still having to spend the same amount of attorney's fees and costs to collect the rest. I'd rather see you contact me and say, Alan, can you please prepare a form for us to use anytime we want to reach a payment plan with an owner that includes concrete consequences for the owner failing to comply. They're going to waive all the pre-suit notices, and if they don't pay, you get to go straight to your foreclosure lawsuit. That doesn't mean that they're waiving everything, but they're going to acknowledge the debt. They're going to say, yes, I owe that. And they're going to say, if I don't pay the way that I'm promising to pay in this agreement, you can file a foreclosure lawsuit, not waste another 90 days, or actually 120 now, sending out pre-suit notices instead of just collecting your money. Now, the association can accept payment over time. You can waive interest or late fees, or you can combine those options. And then the attorney's fees and costs incurred in preparing and monitoring that payment plan should also be covered as something that the owner's responsible for paying. None of this, because you've got an automatic right to recover fees and costs in these collection matters, none of this should be a cost of doing business. All of it should be recovered from the owner, in my opinion. Now, common issues that we see in collection matters coming up is inaccurate accounting. I mentioned, applying interest and late fees wrong is a common problem that I see. The association accepts payments but doesn't tell the law firm that payment was made, or provides a ledger that after the account submitted for collection, if you provide a ledger, that's called an estoppel. Okay, we have estoppel certificates in Florida. Some of you might know, some of you might not know what that is. It's basically a document that says, here's what's owed on the property and here's what needs to be done to bring this back to a current condition. In other words, every problem that we have with this owner is resolved and every debt is resolved through the date that's provided in this letter, if all of that is done within the time frame provided in the letter. Here, if you're giving a ledger or even providing inadvertent access to a ledger and the owner pays the ledger balance, our collection is done. And we have a collection program within the firm where the association pays a nominal fee every year in exchange for our firm taking on all the fees and costs until that matter's closed out. What that means is there are some instances where we've got $5,000, $10,000 into a heavily litigated case. That's fees and costs, but we haven't sent a bill to the association. And if you don't know what those fees and costs are, even though you have access to our accounts online every day, then you might not be including those in the ledger. And frankly, you probably shouldn't. But if you've provided that ledger, or if the owner's gotten access to that ledger and pays the ledger balance without the fees and costs, you're probably not going to be able to collect those fees and costs. So just be very careful about what access is provided after an account's turned over for collection. Tax deed sales are another issue that comes up fairly frequently, less frequently when the economy is doing better, but these will eliminate every lien against the property, including the association and a first mortgage. So we can seek to recover the surplus from that that tax deed sale. Just keep in mind that the lender is going to have a superior position in that surplus. And if they file a claim, they're getting that money before we do every time. Mortgage foreclosures and bankruptcies can delay everything. We'll talk about that later. Judges' decisions. I know you'll be shocked, but a judge is just an attorney that got elected to a position. So a lot of them are far smarter than some other attorneys, but they don't necessarily know this area of law. So sometimes they make bad decisions. And they can also make bad decisions based on what they unilaterally believe is fair, because a foreclosure is decided in equity, meaning that the court looks at what's fair, not just, well, here's the law. Judges also determine a reasonable attorney's fee. I've seen judges reduce those attorney's fees, usually not drastically for our firm, but the bottom line is it's going to be completely in a judge's discretion whether you get back all of your attorney's fees and costs or the judge awards $300 on a $3,000 fee. We will usually try to work with the association when that happens, but frankly, there's nothing we can do to control it because it's just up to the judge. So these are issues we do see coming up where people are kind of activists and trying to help owners against the big bad corporation, the association. When we explain, listen, judge, every penny of this is something that every other member of the association is going to need to pay. I hate to be blunt, but we're not a communist country, so we shouldn't be spreading this among everyone when it's this person's fault. Moving on to collection alternatives and supplements, you can send a rent demand notice if you know that the unit, the lot is being rented. This is not something that requires prior notice to the owner, and it's basically a notice to the tenants that their obligation is now to pay the association all of their rent that they haven't already paid to their landlord until we send a notice saying, yeah, this is paid in full. This is another one where a lot of times my clients will ask us to prepare a form and they can use that going forward indefinitely. And my form is a little bit different from the statutory form. I believe that everyone in the firm prepares a similar one that will also clarify what's also in the next section of the statute after the form letter that says that the tenant can't be evicted for non-payment under the lease if they are paying the association. So we're clarifying, listen, we understand that if you pay us and you don't pay your landlord, that might be a problem, but the statute says they can't evict you for that. If they don't pay under the notice, the association gets to evict that tenant. We can talk about that separately. It's not something I'd like to discuss in detail today because, frankly, most of the time it's not going to be worth the association's funds to do that eviction. Another thing you can do when owners don't pay on time, if they are at least 90 days delinquent, you can suspend voting and or use rights. Voting rights is a questionable one, but just understand you probably have the right to do both of these. If you're considering suspending either of these rights, you'll probably want to run that by your attorney before you decide to do it. You can advance, cause the lender's case to be dismissed, or collect through the lender's foreclosure action. If there's a surplus in the lender's foreclosure case, the first thing that I'm going to suggest to my client is, do you want us to file an affidavit and a motion that we get some of that money to pay down this unpaid assessment? Because we'll get into safe harbor later, but basically when a lender forecloses, the association is generally going to be out a bunch of money if the owner wasn't current in their payments. And chances are, if the lender is foreclosing, these people are not also paying their assessments while they're not paying their lender, and the lender is about to take ownership. Might happen, but it's not likely. We can schedule and or attend hearings in the lender's case, set case management conferences in a lender's case, which is basically us getting in front of the judge and saying, Judge, can you please force them to move this forward? It's been sitting around forever. We can move for a judgment based on just the pleadings that have been filed in the court, if that is appropriate under the legal circumstances. In order to show cause why a judgment shouldn't be entered is a procedural issue. It can be a little bit costly, but it's basically asking the judge, listen, have a hearing. If these people don't show up, enter a judgment. And it's similar to some of the other procedures. We can move to dismiss the case for lack of prosecution, and then we can move forward with our own case, potentially take title and either rent or sell the property, seek surplus funds, like I mentioned, or seek funds that are made available via tax deed sales, which we talked about earlier. Now, let's get into what this collection process actually entails. The pre-suit phase obviously comes before a lawsuit. The first thing you're going to do is send what's called a notice of late assessment. This wasn't required until just a couple of years ago. I won't get into the rationale behind it because I've fought through that long enough now. But this is a letter that's good for 30 days. It basically says, here's what you owe, and it needs to break down on a periodic basis, either through attaching a ledger or actually outlining you owe January's unpaid assessment, February's unpaid assessment, etc., through the date of the letter as to what they owe. The important part here is it cannot include attorney's fees. So usually what we're going to do is prepare a form for the association to use, and it's going to include a form that includes a separate mailing address for if owners have provided that separate mailing address, and a separate form letter if they haven't provided one. And then we're going to provide an affidavit of mailing that's going to include or not include that same mailing address. The reason for the letter is that it's statutorily required. Okay, it's something that has to go out before we can take the next step listed below this. The affidavit is going to serve a different purpose. One, it's going to prove that the letter was sent, but two, it creates what's called a rebuttable presumption. So the court in any foreclosure case is going to be obligated, if this affidavit's included in the file, to presume that that letter was sent in accordance with that affidavit. Meaning the owner really is not going to be able to challenge the fact that this letter was sent if your affidavit and your form are correct. The next letter, once this 30-day letter expires, that's going to go out is a notice of intent to file a claim of lien. We've got statute numbers here. I'm not going to bore you by reading them, but just know that Chapter 720 is the HOA statute, 718 is the condo statute, and yes, there are some similar statutes for co-ops. This is not one that's included in the co-op statute, but it is still a good idea to send it out because most judges that even remotely understand community association law are going to be looking out for this letter to be sent. So this one, the intent to file a claim of lien, guess what it says? We're going to file a claim of lien if you don't pay. Shocking, right? It's good for 45 days, and this is across the board. It used to be different for condos versus HOAs. Now it's 45 days for both types. It's going to provide an updated breakdown and say, we're going to record this lien. This one, instead of like the previous one was just sent via first class mail, regular mail, this is sent via certified mail, return receipt requested with a copy via first class mail. It's going to be sent to the last mailing address that was provided by the owner. We will generally send a copy as well, a certified copy also to the property, so that regardless of whether that owner claims they provided the mailing address or not, it's still covered. Again, this is not statutorily required, but it is recommended, at least by me in a co-op. Condos and HOAs can't record a lien and have that lien be valid until this letter is sent and expires. So you got to send this notice of intent to record a claim of lien. Again, we've got 30 days for the notice of late assessment, 45 days for the intent to lien. Then we've got the actual claim of lien itself. This is recorded in the county public records. It basically tells everyone, hey, this lot, not just this person, but this particular piece of real property, this lot, this unit, this co-op parcel owes the association money. Here's the amount that's owed through the date of this claim of lien. Okay, it's going to secure post-recording assessments, interest, late fees, costs, and attorney's fees. Basically, it secures your entire claim through the date that you foreclose. What's not included is post-recording special assessments, meaning that if you levy a special assessment against this lot or all lots at some point after you record that lien, that assessment requires a completely separate collection process. Now, if you had that special assessment already included, not a problem. It goes into the lien and it's secured. So just understand it's before versus after. Now, the lien statutorily relates back to recording the declaration. What that means is there's a statutory provision that says the lien relates back to the date of recording the declaration. This is for purposes of which lien has priority, which one is superior. But the declaration may limit the lien period to only after an actual claim of lien is recorded. So if the declaration's silent, you relate back. If the declaration says that you don't have a lien until a claim of lien is actually recorded, or at least for priority purposes, it doesn't exist until the lien is recorded, then just understand you're going to go by the declaration in that instance. Now we've got a limited super priority over a second or other junior lien, but generally the association won't have priority over a first mortgage unless their first mortgage was related after the lien. Because if the mortgage was recorded after the lien, the lender gave money knowing that the association might end up foreclosing that lien. So just understand that is one distinction to keep in mind. The lien is going to be subordinate to ad valorem taxes, meaning your tax deed sale is going to wipe out the association except for whatever surplus is available. We mentioned this earlier, but that's what this means. Condo and co-op liens, keep in mind, those are only valid for 1 year from the date of recording. So let's say you record a lien today on January 12th, 2024. If you don't file a foreclosure lawsuit by January 12th, 2025, some attorneys will say that you have to start the collection process over completely. Personally, I think that's the safest course of action. But other attorneys will say that no, you just record a new lien and then you foreclose that one after providing the next notice, which is a notice of intent to foreclose. This is basically the equivalent of the previous one, the intent to lien. Again, 45 days says what's owed. The only difference is that this one is usually going to include a copy of the claim of lien and tell the owner that the intent of the association is to file a foreclosure lawsuit if they don't pay within the time provided. Now, the owners, when it comes to the statute of limitations for HOAs, I mentioned 1 year from the date of recording a lien for a condo. HOAs and the actual assessment installments themselves have a 5-year statute of limitations. What that 5 years and when it starts is kind of up in the air. So you're going to have to run that one by your attorney. I really, really hope you never wait 5 years to file a lawsuit on an unpaid assessment. And that's, again, the conversation I had with a client literally yesterday. I hope that you're taking action because you've got a written policy in place like the ones that I suggested earlier that's going to automate the process of moving that collection forward way before that 5 years elapses. Keep in mind, owners can require the association to file a foreclosure lawsuit sooner, within 90 days, or start over in that collection process by recording a notice of contest of lien. I've seen that happen once in my career, but it does happen. So just be aware of it. If the association gets notice of that notice of contest, send it to your attorney so that you can decide whether to foreclose ASAP. And then even absent an expired intent to foreclose or notice of contest of lien, the association can legally file a lawsuit for foreclosure upon recording the lien. But if the owner pays all assessments, not the interest, not the late fees, not the fees and costs, but just the assessments before a final judgment is entered, the association doesn't recover any attorney's fees and costs. So my strong recommendation, wait the 45 days after sending the notice so that you can recover your fees and costs. You don't want to be out that money. Now, moving on, now that we've sent all our pre-suit notices, they've expired, we get to actually file our foreclosure lawsuit. There are a couple of documents that are going to be included in that lawsuit. I won't go through them in detail so that we can get to more Q&A, but you will have this in the materials, kind of an explanation of what each one of these is. Same thing with who the defendants are. This is just who's going to be named as someone whose interest we are foreclosing. So if I am preparing a foreclosure lawsuit, it's going to include 2 counts, meaning 2 claims. One is going to be for foreclosure, meaning we're asking the judge to set a foreclosure sale date and sell this property at an auction. The other one's going to be for damages. That's only going to be against the owners of the property who owe the money. So you might be naming 4 or 5 other defendants that are not owners of this property. Just understand, it's not we name the owners. That's what we would do in a covenant enforcement context, is only sue the people that are personally responsible for something. But in this context, in collection, we want to make sure we wipe out every interest we can. And so we might name other entities so that the association, if you take title, you don't have an obligation to pay these people off in order for their lien to be eliminated from the property. So there are others that might be named. An owner's spouse might be named to foreclose any potential homestead rights. Any occupants might be named to foreclose any tenancy or occupancy rights, so that the association or whoever ends up with title to this property can actually do something with it. Now, a first mortgagee generally can't be foreclosed and should not be named unless the association's attorney makes the determination that the mortgage lien is inferior to the association's claim of lien. That's an in-depth discussion, an in-depth review that takes about 15 minutes. But the bottom line is, it depends on the circumstances, what your declaration says, the year of the mortgage, etc. But just understand, generally speaking, you can't wipe out a first mortgage unless there are very special circumstances. And naming that first mortgage could actually subject the association to attorney's fees and costs that are payable to the first mortgagee. So if you're questioning why the association is not wiping out the mortgage, that's why. They don't want to end up getting sanctioned by a judge for naming a party they know they shouldn't name. And when I say they, I mean your attorney. These are just terms that go into pretty much any lawsuit, but I wanted to give kind of an overview of how the litigation plays out. The lawsuit basically gives a couple of options of how an owner can respond to the complaint. They cannot respond to the lawsuit. They can file a motion to dismiss, basically saying everything that's stated in this lawsuit taken on face value is not good enough to raise a claim. They will almost never succeed on that in this type of lawsuit. I can almost promise it, at least if our firm is handling your collection work. And then the answer is either going to admit, deny, or state that the owner doesn't know enough to answer regarding each allegation of the complaint. That's also where you're going to see affirmative defenses, of which there are very few in a collection context, counterclaims, claims against other parties who were supposed to pay the assessment but didn't. That's where you'll see not management firms for community management, but property managers being brought into those lawsuits because they had the legal obligation to make those payments and failed to do it, etc. A lot of times this bullet points here because we do routinely have to clean up and ask the judge to force the owners who are filing documents in response to a lawsuit on their own, have them clarify what the heck they're talking about in their response, because we don't really understand. It's written in gibberish. There are no paragraphs. There's no explanation. It's just, well, judge, I think they're wrong, and here's why, and has nothing to do with Florida law. So a lot of times we'll ask the judge to have them clean that up and put it in a context where we can actually respond to it in a legal format. Now, like I said, there are very few defenses to foreclosure claims in Florida. An owner's obligation to pay assessments is conditioned solely on title ownership and proper budgeting and levying of assessments. What that means is anything that's outside of the process of budgeting, levying the assessment, and sending the 3 notices and recording the claim of lien is probably not an offense to this case. So in these cases, the association wasn't maintaining common areas. The owner decided, I'm not going to pay my assessments until they do, and they were foreclosed. And then in another case, this is the Ocean Trail case, the directors violated their fiduciary duty. I believe in that case, it was passing a special assessment that shouldn't have been passed, but it was passed. So the owners had to pay it and then sue to invalidate the assessment and get their money back from the association, not just ignore the fact that the assessment was levied. We talked about estoppel and waiver. We talked about the statute of limitations, so we'll skip that. Now we get to, okay, we've gone through discovery, we've gone, if any, we've gone through the owner's responses and their ridiculous delay tactics of filing a motion for extension, hiring an attorney who then files another motion for extension, filing a bogus motion to dismiss, and then finally answering. Now we get to the stage where we're saying, Judge, we think the facts are completely in our favor. We don't even have to go to trial. And we're basically telling you, you should just go ahead and enter this judgment in our favor. And that's not the association or its attorneys being cocky. That's us saying, listen, Judge, there's no valid dispute as to the facts here. The owner hasn't challenged the fact that they didn't make the payments they were supposed to make when they were supposed to make them. Why would we need to go to trial and take a bunch of evidence when we can put it all in the record? We can just have affidavits that prove our case. That's summary judgment. It's basically there is no issue of disputed fact, okay, or at least no issue of disputed material fact. Now that standard was changed a couple of years ago, I think in 2020, to make it a little easier, frankly, to get a summary judgment. If you have to proceed past there because the judge finds that there is a dispute of a fact that the judge really needs to make a determination on, just understand it's the judge and not a jury making a determination in this case, unless the judge makes a mistake or your attorney makes a mistake, because these are not jury trials. They're specifically judge-only trials in a foreclosure case, because that's the case in any equity case, which foreclosures are. Now, if the case goes to trial, you go to trial and your attorney is going to prepare you for that. I'm not going to go into detail about what a trial entails because, frankly, most of the time in these cases, you're getting your summary judgment. Now, a final judgment is basically a document that says, here's the amount that the owner owes, the damages have been awarded, the attorney's fees and costs have been awarded, and I'm scheduling a foreclosure sale for this date. And if the owner doesn't pay that amount to the court or to the association before this date, the property's going up for auction. Now, the judgment can be satisfied or redeemed. The property can be redeemed at any time before the foreclosure sale, including the morning of the sale. So if you have an 11 a.m. sale, the owner can come in with cash in hand or a check at 9 in the morning to the clerk of court's office and have that sale canceled. The clerk will then eventually, because it's not instant, but the clerk will then eventually disperse the funds and send them to the association. That's also the same thing that happens when you have the foreclosure sale go through and you have a third party that purchases the property. A third party is basically anyone other than the owner, the association, or a defendant to the case that ends up bidding on the property at the sale. So a foreclosure sale is really just an auction of the property. You're thinking eBay basically for houses, for condo units, etc. It's either held online or at the courthouse, depending on what your particular court does. Property's just sold to the person that bids the most or the corporation that bids the most. The winning bidder is going to have to deposit at least 5% of that bid amount before the sale. And by noon the next day, they have to actually come back with the rest of the money to pay off and complete the sale. If they don't, you reset your sale, and generally I will ask the court to disperse that 5% to the association less the clerk's sale fees so that the association is getting back some of its money. That will then reduce the amount of the judgment and the amount that the association needs to recover at the next foreclosure sale that after you reschedule it. Sometimes the clerk will do that on its own. Sometimes the clerk will not reschedule the sale, and you actually need to get in front of a judge to have that sale rescheduled. Better judges are generally going to allow you to do that without a hearing. You just submit the paperwork, the judge signs off and enters the order. A certificate of sale is the document that gets entered after the owner or the purchaser pays their bid in full. That doesn't transfer ownership. What transfers ownership of the property is not the sale, it's this document, the certificate of title. Okay, and that's not going to be issued for at least 10 calendar days after the foreclosure sale. That's statutory. That's giving the owner, frankly, time to file a bankruptcy petition and try and hold up the process. Okay, that document, the certificate of title, is like a deed. It transfers ownership, it gets recorded in the county records. The association should change its records regarding ownership once that document is issued. Now, a writ of possession is another thing that some community association boards don't know about and some managers don't. But this is basically an eviction with a much lower cost. It's usually $200 to $300, I think. And it's basically something that is issued by the clerk of court. It's a document, and the sheriff will then go out and remove anyone that's on the property. So when the association, when some of my clients come back to me and say, this owner's never going to leave, we're never going to get him out even if we foreclose, well, the sheriff might have something else to say about that. Now, the association doesn't get to ask for a writ of possession unless the association ends up taking ownership. So if some third party comes in and buys the property, you got paid. It's none of your business whether this owner gets out. If they are causing a problem and it's a covenant violation, then you would go after the new owner for the problem that the former owner is causing because it's now their property and their problem. Moving on, what else is holding us up? What are other delays that we see? Service of process, which is basically hand delivering a copy of the lawsuit and all the related documents to all of the defendants. These people may live outside the country. We might not be able to find them. They may intentionally avoid the process server, or what we found out in some instances when we go out to serve them because the association was never notified, so the association couldn't notify us, person's actually dead. So that will hold up the case a little bit. It shouldn't hold it up for 3 years. We just get a guardian ad litem appointed, and the judge allows us to move our case forward against the deceased person's either the estate, or if they have a probate filed, we will actually name the estate via the personal representative, and we have an individual who is then personally involved in the lawsuit rather than this vague estate or estate of this deceased person. You also have the process, and HOAs only, of a qualifying offer that can hold you up. The owner is allowed to issue one qualifying offer, which if the conditions stated in the statute apply, means that your case is automatically delayed for 60 days. But that also means that the owner, in my opinion, is acknowledging the debt and the obligation to pay it. So if they don't pay within that 60 days, I've actually used these qualifying offers, which, again, very rare. I've seen 3 in my entire career being filed. But I use them every time to say, Judge, they've admitted in an affidavit, which is what a qualifying offer has to be, that they owe this money. Why would you not just enter our judgment? Then the judge entered the judgment. There's no procedure like this under Chapter 718 condos or 719 co-ops. So just understand, again, this is HOA only. And then we've got motion practice. I mentioned the motions for extension, the motions to dismiss, many of which are just bogus and intended specifically to delay the foreclosure case because some of these defense attorneys get paid based on how long they can delay a case. And then discovery is another one that'll hold us up. You know, if someone claims I made payments that aren't applied on the ledger, my next step is going to be, well, prove it. Okay. Now, some attorneys will send out discovery and say, prove it before we file the motion for summary judgment. Some attorneys will say, well, if they have evidence that says that they made payments, they can present it in response to our motion through an affidavit or some kind of other evidence. So it's really a strategy decision of the attorney. Personally, I'd rather knock that issue out and then let a judge decide based on clear facts when I can say in my motion, Judge, we asked for their proof, they provided none. So moving forward, estoppel certificates and estoppel claims. We talked about these a little earlier. It's basically, here's what's owed. You need to pay it in order to close out this transaction. Usually that's going to be either for a sale or refinance of the property with a clean slate, meaning there's nothing past due. There's no violations on the property. And then there's other information that might also be included in this estoppel certificate. It's also something that the board needs to provide or the association needs to provide within 10 business days after receiving the request for an estoppel, or you can't charge a fee for the preparation or delivery of this document. Now, this is something important that I need to mention right now, because there is proposed legislation out there right now that the legislature is considering that says that the association would not be able to charge a fee for this work at all. So the attorneys and the managers who are taking all of the risk in preparing this either shouldn't be allowed to charge a fee for preparing it, or should pass that cost along to every owner who have every member of the community, none of whom, except for one, have anything to do with this transaction. So my strong suggestion, if you can get out there and reach out to your legislators and say this is a bad idea, and we don't want to be responsible for costs that have nothing to do with our property, I would really suggest that you reach out to those legislators and try and convince them to vote against that legislation. But jumping off that soapbox now, this is a document completed by the association or its designated agent. It's good for 30 days if it's sent electronically, 35 days if it's sent by mail. I literally know no one who sends these by mail. And if you have to amend this estoppel certificate because you find something was wrong when you first drafted it, or there's new information, sometimes that's a new violation that popped up. It's a payment that was made while the estoppel certificate was good. You do need to amend that, send out a new one, and it's good for another 30 or 35 days. We are not charging, in other words, you are not charging as an association for that amended estoppel, period. That's clear under the statute. There are fees that can be charged as of now. Again, that's something that the legislature is trying to do away with. These fees are a little bit outdated, so check. I think the DBPR is who sets these every couple of years. I think it's every 5 years, and these were reset in 2022. So the fact that I haven't updated this just shows how busy I've been, but I plan to update it before the next class I take. If you are not sure where to find that information, I don't charge to respond to emails asking for things like this. Just shoot me an email. Again, Jeff has included my email address in the chat, so feel free to shoot me an email if you need that information for your community. And anything that's not included on this certificate, this is why it's important, it's waived for anyone who relies on the certificate in good faith. So earlier I said, if an owner gets a ledger and they pay the amount that's in the ledger, they're good. They're done. It's the same thing with this estoppel certificate because it's based on the same theory of estoppel. Okay. If there's something that the association was owed that isn't in this estoppel certificate, if that $5,000 attorney's fee for covenant enforcement wasn't on this estoppel certificate, the closing occurs, the estoppel's paid off, and everything else in the estoppel is resolved. You're out that $5,000. Sorry. We're not going to go after it because we're not allowed. Okay, moving on. If the association, okay, we talked about the argument. We're going to skip that, which is good. Fair debt laws, which are completely unfair. The Fair Debt Collection Practices Act is a federal law that prohibits unfair practices in collection of consumer debts by debt collectors. So this is not the association that's responsible. It's generally going to be the attorneys and potentially the managers and the law firms and the management firms. And when I say the attorneys and managers, I mean the individuals. So just be careful that you are not sending demands for anything that you can't collect. Any debt collection letter that's even a penny off from the accurate number is technically a violation of this. And every violation is worth $1,000 unless the judge can decide that that lawsuit against the association's counsel, managers, etc., was filed in bad faith, meaning there was absolutely no basis to file it. Even if that distinction in what the balance should have been versus what was charged actually benefited the owner because you charged them less. So these are laws that are intended to benefit consumers, and as a result, you're not getting your fees and costs back, even if you win. And these are federal cases, which may end up with, $50,000 to $100,000 in attorney's fees, which really means you end up in a settlement. Okay, you're not getting your fees and costs back. Don't take the risk. Do it the right way. If you have any doubt whatsoever about collection practices, contact your attorney and make sure you're doing it right. And then there's the Florida equivalent. Now, this one is going to make everyone responsible for any of those violations. So just understand that includes the board members that are sending out letters. It's not just third parties when it comes to the Florida equivalent. And again, that's $1,000 per violation plus attorney's fees and costs. So bottom line, run that by your attorney before you make a mistake and get tagged with a huge fee. Mortgage foreclosures are another thing that'll hold us up. The lender sued. Now what the heck do we do? It's up to you. Some communities will move forward despite the fact that there's a mortgage foreclosure, knowing that there's a chance that the lender is going to take 3 years to foreclose. And the association might foreclose and either rent the property or sell it to some investor who's going to work with the lender and try and resolve the mortgage, or just rent it out indefinitely until the lender forecloses. So that doesn't necessarily mean just because a mortgage foreclosure was filed that you're done. Generally speaking, we will ask whether the association wants to pursue it or look at it as, listen, this is the risk we're taking. The risk is that if you continue incurring attorney's fees and costs and the lender does finalize its foreclosure action, title is transferred, etc., you get all your fees and costs, all your interest and late fees automatically wiped out at the end of that title transfer. So you're taking the risk that you're going to spend another $1,000, $2,000, $3,000 trying to foreclose and rent or sell the property and then get wiped out, not recover any of that. So that's the risk that you're taking. We can go into safe harbor, but honestly, we're already at an hour, so I'm going to move on from that. But it basically is there is a statutory provision that limits the association's recovery after a foreclosure sale. There is also a provision in almost every declaration, and which one of those controls is a complex legal analysis that you should have your attorney do. Lenders often delay these foreclosures and they eliminate additional assessments, which is why I say just because a mortgage foreclosure was filed doesn't mean you should just sit on this debt. You should be pursuing the debt, but it's up to you whether you want to complete that foreclosure and spend the attorney's fees and costs to move your own case forward. We talked about safe harbor very briefly and frankly just don't have the time to go through it in detail. Bankruptcy, just understand there are 3 different types. Chapter 7 is you're going to avoid personal liability, but not the association's lien. The lien cannot be wiped out and will not be paid as part of a Chapter 7. That's just the owner avoiding personal liability, meaning we can't bring our damages claim anymore for pre-petition debts, but we can pursue post-petition assessments, and we can pursue the lien for pre- and post-petition assessments. Chapter 13, generally speaking, that's a payment plan if you're included in the plan as an association. And Chapter 11 is mostly to avoid business liability. Okay, the main thing you're going to look at is making sure you file a proof of claim. Our firm can handle that for the association. But that's basically a document that says, hey, as of the date of the petition, here's what was owed to the association. That's because we want to make sure that the association gets paid either through the plan or is allowed to proceed outside the plan with our standard collection protocols. Now, the debtor may seek to strip the association's lien. That option only exists in Chapter 13 and 11. So if it's a 7, that's not an option. It also requires that all of the owners be co-debtors in the bankruptcy. And finally, it requires that there be 0 equity whatsoever after superior liens are paid to actually pay the association. So if that property is worth $500,000 and there's a mortgage for $499,999.99, there's a penny left over to pay the association. That lien removal is ineffective and it won't go through if the association challenges it. Bankruptcy, like the Fair Debt Collection Practices Act, is something intended to benefit the debtor. That's going to be your owner in these cases. And that means that even if it hurts the creditors, it's something that's going to happen. The important part for you to know that will impact our collection efforts is that this is not an optional, well, we can stay or we can go. This is, if there is a bankruptcy petition filed, there is an automatic stay of collection, all collection, that is imposed as soon as that petition is filed and until the judge says otherwise. So just understand, we are not going to break that stay. We're not going to violate it and try to continue collecting while we're not supposed to be doing it. You can have us try and lift that stay if we're your counsel upon a lack of adequate protection of interest in the property, meaning that you're not getting paid under the plan. The fact that the debtor lacks equity in the property, and in Chapter 11 and 13 cases, Property is not necessary to reorganize the debtor's debt. So bottom line, I think we have a great collection program. We've got some great collection attorneys, but that's not what we're here to talk about. I'm happy to discuss that outside of this webinar, but this is intended for education, not as a plug for our firm. So I'm going to leave this slide up for just a moment, but Jeff, I'm going to let you do your thing.
Alan, back to you.
All right. Well, I mean, the good news is I anticipate I should be able to get through most of what we're talking about here, at least what's been submitted as of now. So I will add, and I see that there are some people that have already emailed me asking questions. That's fantastic. Frankly, that's the easiest way, in my opinion, to get in touch with me and ask me these questions if it doesn't get answered during today's webinar. It's also the easiest way to get in touch with me if you'd like to start working with our firm or and end up with a free consultation regarding any of these issues. But you're also welcome to submit that as part of your survey response. Now, getting into the actual Q&A, Barbara asks, what's your advice for repeat offenders? Owners don't pay for months. We go through collection. They end up paying. Once they pay up, they turn around and stop paying again. I think that's why I suggest having a collection process where, yes, okay, absolutely, this owner might not pay, but they know that they are going to end up responsible for all the fees and costs incurred in the collection process. So if you're going through and not giving them a bunch of time where they have, 6 months to pay before you're taking any action toward collection, if you're giving them 30 days, then you're sending out the notice of late assessment. And after 60 days from the date that that assessment was due, it's already being sent to my office to try and collect the assessments, and they're paying attorney's fees on day 60, then they're not going to be more than 60 days delinquent more than 1 or 2 times before they say, I don't want to pay this attorney anymore. I'm going to go ahead and either pay on time or at a maximum pay within those 60 days. But make sure that you're not waiting too long to send that notice of late assessment out. That's my suggestion as to how you deal with those repeat offenders. Whether you do that via a written policy that says you're going to do it so that every member of your community knows that that's what you're going to do, or you show by action that that's what you're going to do by simply going out and sending that letter 30 days after they go delinquent or 31 days or whatever it is. You just got to let people know that you're going to take your collection seriously. The people that are not seeing you take it seriously are the ones that are going to be repeat offenders. Because if they end up getting tagged with a big attorney's fee, they're going to stop screwing around the way that you were describing, where they are, they pay on time and then 2 months later, they don't pay again. Moving along to Dan, you talked about 4 policy programs. One was a written collection policy. What were the other 3? And can you elaborate on why we should have these? We're a condo association. Well, thank you for clarifying the condo part. I don't know that that's relevant here because I recommend this for every community association. But the 4 policies I mentioned were collection, meaning your unpaid assessments, covenant enforcement, meaning people are not doing what they're supposed to do in the way that they're using the property and acting in the community. The other ones are member participation at meetings. And the last one is records inspections, meaning people are getting access to your records, making copies, etc. The reason you should have these is because they basically outline the process you're going to follow. And if I prepare them, I have a flat fee of 3 hours for any new client that comes in or any older client to prepare this package of 4 policies. And once you send that out to the members and they know exactly what you're going to do and you follow that, you eliminate almost every possible defense to your covenant enforcement, to your collection, and you eliminate a lot of the problems that people have with members that don't allow the association to actually conduct business because frankly, they won't shut the hell up. And with members that are sending 4 or 5 records inspection requests within the course of a month. Now, you may not have that now. You may have everyone doing exactly what they should. But the second you get someone in the property that's causing problems, you're going to wish you had these policies. And that's why I say everyone should have them. Because as soon as you start adopting them in response to finally having a problem, they're going to know, 1, it's reactionary, and 2, they can say, well, look at Judge, they adopted all these policies just to stop me from doing what I'm doing, which I have a legal right to do, whether they have the legal right to do it or not. So that is my recommendation. That's why I say you should have all 4 of those policies, because they're the 4 major issues that people can easily cause problems in your community by not doing what they're supposed to do. And this will kind of curtail that behavior. Jeff, I see that you pulled the Q&A. I'll let you do your thing.
I just sent you, I need to keep the questions from getting out of hand so we can get to all of them like you mentioned. So I just sent a direct chat to you with the next question, and I'll do that for each one, for each subsequent one.
Okay. Well, I addressed Dan's question, so if you can send me the next one, let's move on.
Oh, apologies there.
That's okay.
Here we go. All right, Joel.
Joel, thank you for being here again. Does an owner need to pay an assessment plus interest, not fees, etc., to be a candidate for the board? Is there a grace period for regular budget payments or special assessments? There is a 90-day grace period. An owner who is delinquent in payment of any of those charges technically can be kept off the ballot if they're delinquent as of the last date that they can nominate themselves, whether you're in a condo or an HOA. If you're in an HOA, that may be the date of the election. If an owner becomes 90 days delinquent at any time during their tenure, regardless of what the obligation is, technically they are removed from office. So they won't be directors anymore at that point. Christopher Carter, how does debtor's right of redemption come into today's topic? The right of redemption is the right of an owner who is being foreclosed to actually pay the amounts that were owed at any time before the sale. So that redemption is you are redeeming the property by paying the debt to the courthouse. You're paying at the clerk of court's office. So I may not have used the term right of redemption. Maybe that's why the question came in, because I just said they can redeem the property. Those are the same thing, just to be clear. Karen Volpe, can you lien if fines are not paid? Only in an HOA and only if your governing documents say that you have the authority to lien for fines. In a condo and a co-op, you cannot lien for fines. And in an HOA, generally speaking, you can't. Fines in an HOA need to be at least $1,000, and your governing documents need to say that you can levy those fines as an assessment against the lot or otherwise record a claim of lien for unpaid fines in order to do that. Moving on, Joanne, what happens to collection fees and attorney's fees if the statute of limitations eliminates the assessment? Are the collection fees eliminated also if a lien has been filed? Now, if a lien has been filed, the answer depends whether you're talking HOA or condo/co-op. If you're condo or co-op and that 1 year statute of limitations passes, you generally, in my opinion, need to start over and those attorney's fees and costs go away. Because frankly, in my opinion, the association made a mistake by not filing a foreclosure lawsuit within a year after that. I know that you needed to send that 45-day notice of intent to foreclose, but that means that you had 10 plus months to decide to file that foreclosure lawsuit. And frankly, if you chose not to do that during that time, unless you had some reason like a mortgage foreclosure or a bankruptcy to choose explicitly not to file it, and you made the conscious decision to forego all those fees and costs, it should be on you to start from scratch. Now, in an HOA context, that's really going to depend on what the judge interprets as even being the statute of limitations. There are some cases out there, and I'm not saying this is the case for everyone across the board, and I strongly recommend that you get your own counsel on this particular issue, the statute of limitations in an HOA. But the bottom line is, it essentially is if you filed your foreclosure action and you included amounts that should not have been included, a judge has some discretion to basically say, I'm not going to award those assessments that accrued more than 5 years before this lawsuit was filed, but I will award everything else, including those fees and costs. There's also the risk, however, that a judge says you can't foreclose at all because your pre-suit notices included amounts that at the time that this lawsuit was filed were more than 5 years old. So again, that's one of those, I really think you need to get your own counsel, primarily not because you have to get separate advice from what I'm capable of giving, but so that you have something in writing that the board can then rely on if the owner then tries to file some kind of fair debt claim and claim some kind of breach of fiduciary duty by you going after amounts that in their opinion you shouldn't be collecting at all anymore. Doug asks, on the president of a condo association, is there a difference in the remedies available to a condo and the process to be followed if the owner's delinquent on a monthly assessment or late paying a special assessment, or if they're late on both? No, you follow the exact same procedure. The only distinction between a regular and special assessment is that you might be accounting for them separately. So you might send a separate demand, but there's literally no reason you need to. The only distinction would be, like I mentioned during the webinar, if you've got a claim of lien and then you levy a special assessment that wasn't included in the lien. Excuse me, that's a different story. Or that the assessment came due after the lien was recorded. Then you'd have to start a new collection process for that special assessment. Corinne asks, how many notices should be spent if special assessment was from June to November, but no one sent an invoice to the unit owner until December? Then you didn't have an assessment until December. That's my opinion. Some owners didn't pay. Now there's over 100K before we can start the project. Shouldn't an invoice be sent after the first 2 or 3 months payment was not received? Now, I think when you say invoice, you actually mean, shouldn't a delinquency notice be sent? And the answer to that is yes. My opinion is if the assessment was levied in June, you should have been sending a notice in July or August saying you didn't pay on time. The fact that the entire assessment hadn't been due yet is not relevant in my opinion. You shouldn't be waiting until December to say, hey, you didn't pay this. Again, collection policy, collect after 30 or 60 days. Even if you go to 90, that's stretching it a little bit, but it's okay. But if you're sitting here and waiting 7 months, 8 months from the date that the first installment was due, you're making a mistake in my opinion. Can you ask for an accounting from the manager on your unit account? The answer to that is yes, you absolutely can. That's part of a records inspection request. And if you're not in collection, management might give you access to that directly through their system. If you have like an online portal, you might have access to that directly. Victor asks, if an owner receives a notice of late assessment with a ledger, makes a partial payment, reducing the amount to delay going the attorney, will a new notice of late assessment be required if the owner delayed it for over 2 months, or would the notice of intent to file a lien reset the amount to be paid? So let me clarify again. You send out the notice of late assessment. The owner makes a partial payment. That payment gets applied pursuant to Florida statute. Gets applied to interest, then late fees. There won't be any attorney's fees and costs yet, and whatever's left gets applied to the assessment. The remaining balance is what you are going to move forward with that notice of late assessment to still try and collect, unless you're able to work out the remaining balance with the owner, or you're willing and able to waive the interest and late fees. But you don't have to start over. The owner doesn't get to delay the process by sending a partial payment. What I suggest is sending them a courtesy notice that's not statutory, but just a, hey, we got your payment. Our attorney tells us, and get something from your attorney. Even if that's me, get something in writing from me separate from this webinar. But our attorney tells us that we need to apply this payment in this manner because that's what the statute requires. You still owe X dollars, and here's the breakdown of that. If you don't pay it within the time provided in the existing notice of late assessment, we will proceed pursuant to our written collection policy. Terry asks, an estoppel didn't include violations for the seller. New buyer was issued those violations for roof cleaning, and the association's going after the new owner. Can the association pursue those violations, which should have been for the old owner? That's not really the subject of this class. That would be better for a covenant enforcement class. But
Right.
generally speaking, it depends whether it was something the association noticed or should have known about beforehand. I can't give you a concrete answer without more facts there. If you want to email me, feel free. Richard, thanks for providing the seminar. You're very welcome. I'm a board member of a 30-unit condo in Fort Myers. The board's debating the process and documentation needed to bill 11 of 30 owners for their air handlers. These were paid for by the association, not covered under FEMA flood insurance settlement. The 11 owners were charged via an email invoice. One owner is disputing it. Honestly, this is a I need to look at your documents question. And if you want us to work on this for you, Richard, please feel welcome to email me separately. But this is not one that I'm going to be able to answer without looking at your documents to see what is a proper assessment under your declaration. If this charge is a proper assessment, then yeah, you can require them to pay it. It wasn't in the budget or included in a special assessment. Which is the best opportunity, an invoice via email or a special assessment with adequate documentation?
That was part of that same question. There wasn't enough.
Yeah,
The chat only lets me do so
I
many.
gathered that. I mean, again, I really need to look at your governing documents to really give you any kind
Right.
of remotely concrete answer on that one. So, Richard, if you want to shoot me an email, I'm happy to work with the association on it. But what we would do, as I do with all new clients, is pull a copy of your governing documents, compile them all for you, and then get you the answer as part of the email sending over those governing documents. Moving on to Guillermo. What about if the tenant decides not to pay after receiving the attorney's notice due to the owner delinquency? That's if the tenant gets a rent demand notice and doesn't pay. If they're not paying because they already paid their landlord, they're actually doing it right. If they're not paying because they're being a pain and they don't want to pay the association can legally file an eviction lawsuit and have them removed from the property. That tends to work better in areas where it's really easy to rent out, like Kissimmee and areas like that. Some areas in Miami and Fort Lauderdale where they're going to get a new tenant in there tomorrow. And yes, they probably have first, last, and security from that new tenant, but you send the notice and say, we understand you may have paid the rent this month. We're still going to require you to make the payment next month. And if you don't, guess what? Here's a copy of the public record that shows that we evicted the last tenant. What do you think is going to happen to you?
Yeah. So now with including Glenn's question, we're on the last three.
Okay. What's the process when the delinquent owner has a chapter 11? This is bankruptcy for those that don't understand the question. Payment plan and the dues have increased. What if he doesn't pay the additional assessment? What you're going to do is have your attorney file a notice of payment change in the bankruptcy case, which will notify everyone, including the debtor, which is the owner, of the obligation to make the correct payment going forward. Just understand, if that payment is going to change in January, you need to send that notice in December. Otherwise, if the payment was due January 1st and you send this on February 15th, that payment is not going to be changed. It's only going to be the subsequent assessments that the owner is actually going to have to pay for. Enrique, good to hear from you. A unit's under legal case and is being more than 2 years without paying any fee for administration and HOA fees. I'm guessing that means assessments. What are legal rights to collect those fees since the legal case still open under the Florida Supreme Court? I mean, if they're not paying assessments and this case isn't directly related to assessments, you proceed with your standard policy and your standard procedures for collection. The fact that someone doesn't agree with what the board is doing or doesn't agree that they are in violation of the covenants is completely irrelevant, like I mentioned earlier, to their obligation to pay assessments. So you would sue them if you would send out the standard notices and then file your foreclosure lawsuit, regardless of any Supreme Court case that might be going on. In your experience, Gerard, are you finding that those in arrears are resident homeowners or rental investors? Yes. The answer is both. It really doesn't change very much between one or the other. I've found that the residents are more likely to make payments, but they're also less likely to have extra money lying around when an association levies a special assessment. Because most of the time, I mean, we're in Florida. I won't say most of the time, but a lot of the time, especially in southern and central Florida, you're looking at people on a fixed income that can't afford a rental property and can't afford a special assessment because they've budgeted just to barely afford where they're living now. And I won't get on the soapbox about the increasing insurance costs or the condo bills that have come out over the last few years, which I'm sure we'll be addressing in the Castle webinar in the next few days. So
Yeah.
that's all we've got, I guess. Again, thank you everyone for attending today, especially those of you. We still have 120 people on the line right now who stuck around. I really appreciate you sticking it out. Feel welcome to reach out to me anytime if you need any kind of guidance, or I'll be candid, preferably if your association needs counsel, at as@kbrlegal.com, or you're welcome to call our office. I'm not the guy that you need to schedule a call with. If I'm available, I'll take your call. Another important thing that I don't usually point out, but I think for this in particular, we do have an online system where you can see what's going on with all your collection matters at any given time online. You don't have to reach out to an attorney, but I do personally have a policy where every client will get a responsive email or call, whether substantive response or not, just an acknowledgement within 24 hours after I hear from you. So I will leave it to you, Jeff, and I'm not necessarily jumping off, but I really do appreciate everyone sticking around so long, especially since we're still at around 120 people.